KnitPro, Group LLC, and MS Indeutsch International.
Mr. Edinburgh.
My lords, I and my learned junior Stephanie Wickington appear for Crafts, who are the appellant in this matter, and they were the claimants below. My learned friend Guy Hollingworth appears for KnitPro, and they are the respondents, and they were the defendants below. My lord, subject to your lordship's view, with respect to the announcement made by Baroness Carr in November last year, we were not going to divide the submissions between leading and junior counsel because there's not enough basically here to divide sensibly, my lords. You should have 3 bundles: core bundle, a supplementary bundle, and authorities bundle. And there's also some loose cost schedules that have been handed up to you in the last couple of days, 24 hours or so. Whether we get to that is a separate matter.
We've certainly seen the 3 bundles. I'm sort of aware of seeing at least one cost schedule, but on the assumption that we're going to end up with a written judgment, we needn't worry too much about costs at this stage.
That's rather what I thought, but I just wanted to make sure that you're aware of the flurry of papers that have happened in the last 24 hours or so. My lord, with that, by way of very brief introduction, I was going to set out the factual matrix. I'm afraid this is going to be slightly longer than it would otherwise normally be because the matter's been going on for some while. And so if you'll indulge me for that.
I mean, I should say we have all looked at these papers
Yes.
reasonably thoroughly, but at the same time, given the complications, I'm certainly not going to discourage you from giving us some insight into what's been going on.
My lord, and thank you for that indication. I was going to try and do it fairly briefly, but it was basically to explain the to-in and fro-in in the way in which the litigations and the pleadings have progressed. So I was only going to touch upon the highlights. I was not going to take you to all the detail. If you wish, I can, but there is, for your notes, a useful chronology in the core bundle behind tab 3 that starts at page 30. And, my lords, this matter concerns a dispute about crochet hooks and knitting needles. And just so that you can get a feel for the actual subject matter, we might as well go to the pleadings in this matter. And the first place is the re-amended particulars of claim, paragraph 3, which may be found in the supplementary bundle behind tab 2, commencing at page 6 of the bundle. And in paragraph 3 there, and under 3A, you see what's called the Chevron Mark. Can you see it's 2 parallel lines with some parabolic curves? So it's a black and white mark. And then in 3B, you see what's called the Symfonie Mark, which is a pictorial representation of a coloured knitting needle. And then if you go to the reply and defence to counterclaim, which is in the same bundle, but this time behind tab 4, and if you go to page 37 of the bundle, and this is paragraph 2E, you'll see at the bottom of the page a representation of some of the Symphony single and double pointed needles. And then if you turn 2 pages to page 39, you get a photograph of some of the Caspian and Sunstruck products, which are the alleged infringing products. And you can see the crochet hooks on the left 2 pairs and the knitting needles on the right 2 pairs. So that's just to give you a feel of what the subject matter is all about. Now, in January 2013, the claimant, so that's Cross, made an application to the European Union Intellectual Property Office for a declaration of invalidity of the Chevron Mark. That was the first mark that I showed you, the black and white representation. And then a little bit later, in June and October 2015, the defendants in essence sought takedown notices from Amazon with respect to the Caspian and Sunstruck products that I've shown you most recently. And there was a delay until December 2020 when the claimants issued proceedings for unjustified threats of infringement proceedings. My Lords, do you want me to very briefly unwrap that? I know my Lord Justice Arnold understands what the threats proceedings are, but very briefly, within intellectual property matters, there is a cause of action whereby if somebody goes around and makes threats of issuing proceedings for an IP right, then an aggrieved party may bring freestanding proceedings to stop those threats if those threats are unjustified.
Now, just a quick question on that point. It doesn't much matter, but for my own interest, I was trying to find the takedown notices in the present case. Do we have them in the bundles or not?
No, I don't think we do, my Lord.
Right, that's why I couldn't find them. Fine.
Exactly so, my Lord. The reason is because, in essence, that's not the core of the dispute. Whether or not they amount to an unjustified threat is a separate issue, but that's not part of this appeal.
Well, of course it isn't, but it is one of the issues you identify as being live in the proceedings, subject obviously to the impact of this court's decision in Nokia and Kharkiv. Yeah. Yeah. All right. Thank you.
My Lord, I've just been told, actually, we were never given copies of them. So that would also be just like I can't find them.
Yes, but they're referred to
they must,
in the pleadings.
They are
so
referred to in the pleadings, yes.
If they haven't been annexed, then you
No.
can obtain them in the usual way.
Yes, I thought so. Right, so where I got to was that proceedings had been issued by the claimants for unjustified threats. And then, after a bit of toing and froing with respect to the service, the defendants made an application that the court, that is IPEC, the proceedings were issued in IPEC, the Intellectual Property and Enterprise Court, for lack of jurisdiction of IPEC and also for a stay application. And that hearing was heard in November 2021 by the Deputy Judge, Mr. Ian Carrott, who refused both parts of that application. And so therefore, pursuant to that judgment, IPEC had jurisdiction and the stay was refused. Therefore, the matter progressed. And in October 2022, the defendants filed a defence and counterclaim. Now, as is the normal way with a threats proceeding, the counterclaim was for infringement, because if there is infringement, then the threats are justified, therefore the unjustified threats provision fall away. And that infringement allegation was predicated upon two EU trademarks, so the Symfonie and the Chevron EU trademarks. Now, you'll all be aware that Brexit occurred, and one of the consequences of Brexit is that EU 28 marks pre-Brexit, by EU 28 I mean marks that have been registered at the European Intellectual Property Office that had effect through the 28 member states of the EU prior to Brexit. They automatically, on IP completion date, divided into an EU 27 mark and a UK comparable mark. So both marks split. Now, in response to the defendant's defence and counterclaim, which invoked the infringement of the EU trademarks, the claimants raised various defences, including the invalidity and revocation of the Chevron Mark, which is the black and white mark, but didn't attack the Symfonie Mark, which is the coloured mark. And there are various other defences as well that were raised. The matter progressed, and in May 2023, there was a CMC application heard before the IPEC judge, His Honour Judge Hacon, and there was also at that CMC, and actually comprised the majority of the hearing, the defendant's stay application. So at that stage, they're coming back and saying, now we have all the pleadings, there should be a stay of the matter, and that was heard before His Honour Judge Hacon. Now, that resulted in a judgment, which is the first judgment, 16th of June 2023, and you'll find that in the core bundle behind tab 5, where the judge stayed all matters. Now, what then happened was that there was an application for permission to appeal, and the defendant, one of those grounds was that the judge had given insufficient reasons. And the defendants wrote to the judge, in essence pursuant to the case of English, paragraph 25. It wasn't going to take you, but for your note, it's Authorities Bundle, tab 1, page 13, asking for the judge to give further reasons, which he duly did. And that was in the second judgment, 26th of July 2023, and you'll find that in the core bundle behind tab 8. The claimants took the view that it was all still insufficient and wrong in any event, and we end up with the amended grounds of appeal, which are in the core bundle behind tab 1 at page 15. So what one has here is grounds 1, 2, and 2 capital A relate to the exercise of the regulation, which is the EU trademark regulation, and it was alleged that there was an error of law with respect to how that had been exercised. And then with respect to that part of the stay application that was made under the CPR, grounds 3 and 4 say that the exercise of that discretion under the CPR stay provisions was flawed. So that's where we get to with respect to the 5 grounds of appeal. And then, moving on, so one then has all the matter before the court, the standard logistical stuff about filing skeletons and what have you. But on the 6th of November last year, the defendants withdrew their EU trademark infringement allegations. And then, January of this year, they filed an amended defence and counterclaim. And just so as to make good what I'm about to say, you can find that in the supplementary bundle behind tab 3, page 14, paragraph 1, the last sentence in red. This amended defence and counterclaim is subsequently served upon the second defendant's discontinuance of its counterclaim for infringement of the 2 EU trademarks. So that's the EU version of the Chevron and Symfonie marks. Now, the discontinuance has a number of consequences. The cost consequences in IPEC are not for you. That will be dealt with eventually in IPEC. There's obviously, if that part of the original case has been discontinued at first instance, then there's going to be a knock-on effect of the matters before your lordships, because of course grounds 1, 2 and 2 capital A now have no purpose. And so therefore there's a cost consequence vis-a-vis that. And the long and short of all that is that you now no longer need, in my submission, to look at grounds 1, 2 and 2 capital A. We only need to look at grounds 3 and 4, which are to do with the exercise of discretion under the CPR for a stay.
Well, I don't think there's any dispute about that, because the defendants have explicitly said that they're not contesting grounds 1, 2 and 2A.
Yeah.
But they do support the judge's case management decision, and hence they resist grounds 3 and 4.
Yes, and therefore there's still something before you. Probably parenthetically, but I'm sure you're all aware of it. Of course, my Lord Justice Arnold granted permission for 3 and 4. That was nothing was granted for permission by the judge. I can take that to you, but I'm sure you've seen it already.
I think we are familiar
Yeah.
with that. So what we're concerned with now, as I understand it, are first, is this a situation where the judge is taken as having made a decision such that it's necessary to show that he went wrong in some way in that decision? Or if that isn't the case, because really we're dealing with a different situation, do we now decide what the right course to take in case management terms is? Or indeed, do we send it back to the judge for him to decide what in this changed situation the right course would be to take?
Well, Lord, I think you've asked me 3 questions. If I might answer the last one first. My submission is that this court, assuming that you have jurisdiction and you are going to interfere or could interfere, you should interfere. And the reason for that is basically proportionality. We're all here. We've all argued it out in the skeletons. Broadly, you're in as good a position as anybody else. And it would just be a waste of time and effort to go back. You could send it back, there's no doubt about it. But you could exercise your discretion afresh here and now, and I would press you to do that because it'd be the most efficacious way forward.
Yes.
I need to answer the first and second question, and the short answer is yes to both, because we say, first, the judge, when he exercised his, I'm going to call it the CPR stay discretion, we say he exercised that on a false basis, basically because it was tainted by his decision with respect to the EU stay decision. And so therefore that gives you a mechanism to say his exercise of discretion was on a false basis and therefore you can interfere. And the second point, which is your second question, my lord, is that because the landscape has changed completely, that which was decided by the judge at IPEC level can't stand because you're now looking at a different case. I think that deals with all 3 of your questions, my lord.
And these are the points I take it that you will be developing in your submissions. Yes.
So that was all I was going to do by way of background. It was pretty blitzkrieg, but it touches the main points. It shows you how the back and forth goes between a threats action, you then sue for infringement or allege infringement, do you then defend that by saying that the mark upon which you're infringing is invalid or should be revoked or something, or there's no infringement, and how we all end up here.
Yep.
So the substantive point was I was now going to deal with why the exercise of discretion by the trial judge, well, the applications judge, but the IPEC judge, at first instance under the CPR can be interfered with.
Well,
And
before we do that, might it not be helpful to ensure that we're all on the same page as to the current state of play, as to which my understanding is as follows, namely that on the 15th of December, the Grand Board of Appeal issued a further decision with respect to the EU Chevron Mark, which could colloquially be called a score draw, because they rejected the allegation of invalidity under Article 4 of the 2009 regulation, but they said that the mark was inherently devoid of distinctive character, which of course left still to be determined the plea of acquired distinctive character, so they remitted to the opposition division. Sorry, cancellation. Cancellation.
Must be cancellation, yes. Yes. But we're also within the period in which to appeal.
Yes.
Sorry, both parties.
Both parties could appeal, yes. Or one, or neither.
My lord, yes, you've covered the options.
And
Sorry.
at this stage, we don't know.
That is true, my lord. And furthermore, I cannot help you further because I do not know what my client wishes to do on that.
Remind me, when does the period for filing notices of appeal expire?
It's a simple question. The answer is not straightforward. I set this as a problem for my pupils, and they cursed me forever after. That's why I don't have any pupils anymore. First point is, it's 2 months. That is set in the regulation, the EU TMR regulation. The second point is you need to know when the 2 months starts. That is 5 days after it is notified to the electronic email box of the party. That is pursuant to a presidential edict, the number of which I forget, but I can find if you need it. Then you need to know, you now know when it started, you've now got the 2 months. Then there's a 10-day extension period on top of that. That comes from the Court of First Instance Rules of Procedure, and I think it's Article 60, which is because the European Union is so big and everything goes by pigeon post, it takes 10 days to arrive. And then there's a further provision that if that then falls on a closed day, you can roll over to an open day. So broadly, it's 2 months, 2 weeks and a bit. But without knowing the precise, there's another problem. The notification only works if you've signed up for the system. Otherwise, there's a different triggering mechanism for the notification. And the date of notification doesn't count. So if you're notified on the 1st, everything starts from the 2nd. Does that answer your question?
That's very helpful, thank you. But where that leads to is this. If we assume that this court reserves judgment, and if we assume that the judgment is not going to be available until, let us say, just for the sake of argument, the 1st of March,
yes.
By that date, one ought to know whether notice of appeal have been filed or not, or it's going to be close at any rate.
That's going to be close, actually.
Yeah.
I'd have to look at the exact dates and the exact mechanism of notification to give you a final answer.
All right. But as we sit here today, all we can say is there's a time which is running, and both parties might appeal or they might not.
Correct, my lord. And to feed into that mix, you will have observed that every decision that has potentially been capable of appeal within the EU trademark system has been appealed by whichever party has been aggrieved at whichever stage.
Yeah. Hitherto a 5-year period has been assumed for final resolution at the European level.
My lord, yes. That was a broad estimate.
Given all the various possible permutations, it's a bit anyone's guess, or is that overstating it?
It's finger in the air. I mean, it has gone on a long time, even by my experience. I've done 50 of these, so I mean, it is a long time. but it's perfectly feasible. We've only been to the General Court twice. We're probably going to go back for a third time. It's possible we could go to the Court of Justice, and the reason I say that is historically you could go to the Court of Justice as a right, but now it's been restricted because there are too many trademark appeals and you have to raise a decent point of law. But there's a decent point of law in this, or at least somebody could construct it, I'm sure. So there's a risk of that. And as my Lord Justice Arnold pointed out, currently it's been kicked back to the cancellation division to determine the issue of acquired distinctiveness. So we've now started back at the bottom. So it's the cancellation division, the Board of Appeal in Alicante, the General Court in Luxembourg, and the Court of Justice in Luxembourg. So there's lots of snakes and ladders. My lords,
Yep.
does that sort of give you enough?
Thank you.
Otherwise, it's a long lecture on general court procedure, which I probably don't think anybody's interested in. My lord, I was going to deal with the law on how you can reopen things, and in particular the exercise discretion with respect to the CPR point. That is most conveniently dealt with in APB technology, which may be found in the authorities bundle behind tab 7, and it's paragraph 21, which may be found on page 122. And what we're doing here is it's the quote from Azam, which is the relevant bit. And principles applied on appeal from the exercise of discretion been addressed in many cases. I'll only refer to the useful summary in Azam. Starts quoting from paragraph 50 of that. The appellate court will only interfere with a discretionary evaluation where the appellant can identify one or more of the following errors. Little Roman 1, a misdirection in law. Little Roman 3, that the judge took into account irrelevant matters. The long and short of it here is that when the IPEC judge exercised his discretion under the CPR to impose a stay, we say that that discretion was tainted because of the way in which he had decided to impose a stay pursuant to Article 132 of the EU Trademark Regulation. And that is because you can see that the whole of that part of his judgment in the first and even the second judgment is he's in essence talking about the EU TMR exercise of discretion and how he can stay the matter. In fact, mandatorily, he thought, stay the matter with respect to the EU trademark infringement part, predicated upon the point that there was an invalidity action before the EUIPO of the Chevron Mark.
Could I just go back to what you were saying to us earlier, because you made clear that you have a second string to your bow, which is that the landscape has changed completely anyway. Now, if we, in a sense, that logically comes first, because if we accept that submission, then we don't get into the question of whether the exercise of discretion was tainted.
My lord, yes, I was dealing with it chronologically, but yes, logically, you can do it the other way around.
Yeah.
I mean, sorry, I wasn't giving preference to that first argument.
Understood. Thank you.
So, coming straight on to the point that my Lord Justice Arnold has just raised, you've now seen that the case before His Honour Judge Hacon in the IPEC was that there were allegations predicated upon the infringement of the EU trademarks. And now there aren't. That's being withdrawn. Therefore, the whole landscape of the factual matrix upon which he made his decision has changed. And he never, in either of those first or second decisions, considered the hypothetical case, which would be hypothetical before him at that time, that there was no EU element at all. Because however he looked at it, there was always an EU element. And so, basically, I mean, I could go into more depth, but I mean, that's really all I think I need to say at the moment.
I mean, I suppose it may be said against you, well, there still is an EU element in reality, not in the pleadings, but the outcome of the European processes will have an impact.
I was going to deal with that when I came to the merits.
Yes, I follow.
Yes, that's absolutely right. I say to a very small and a very controllable extent, but there has to still be an EU element because there still is something before the EUIPO. At the moment, it's gone down from the Grand Board of Appeal back down to the cancellation division. Oh, sorry, I better explain to some that when I mentioned that there was a cancellation division, Board of Appeal, General Court, Court of Justice, there's a little bit of a side shuffle. You can go from the Board of Appeal to the Grand Board of Appeal, but that's not an appeal. It's actually just a shifting of the decision-making tribunal to something that's larger than the normal Board of Appeal. It's not a separate appellate route. What happens is that only happens when there's conflicting Board of Appeal decisions and they feel that the Grand Board ought to do with it. It's different from the EPO scheme where the enlarged Board of Appeal and the EPO actually is an appellate level above.
Wow.
My lord, I was trying to, forgive me, I was trying to be brief on that point. And it's only parenthetical, so I can just drop it.
Yeah, I mean, the closer analogy would be cassation. It's not really cassation either.
Yeah, it's the sort of judicial review using another not quite accurate term.
But I don't think we need one.
No, I can put that to one side. I shouldn't have said it. I should have just left it out. And I've said, of course, that when the judge never considered a case with no EU element at all, he had always in the back of his mind, you can see this from the way in which his first and second judgments were structured, that the court did have EU jurisdiction. So that's another tainting consideration. But anyway, that's how I say that we can now view the matter again. And unless you have any further questions on that, I was actually then going to jump into
What one might do if one were looking at it afresh.
exactly so. The easiest way of looking at this, oops, Daisy, is that there is a case in the Court of Appeal that deals with a sort of rather similar analogy, which is whether or not one should be granting stays in this jurisdiction when there are simultaneous proceedings occurring in the European Patent Office. So that concerns patents, and this obviously concerns trademarks. So it's similar but not the same, and I'm not going to risk trying to say too much on that again. But if you go to the first judgment, which is behind tab 5, and if you go to paragraph 65 of that, which is on page 50, so the core bundle, tab 5, page 50. And so what we're looking at here is the IPEC judge talking about this patent case. In IPCOM, Lord Justice Floyd noticed that the earlier guidance in Glaxo had been overtaken by the judgment in Virgin. And then he carried on. In the light of the observations in Virgin and the arguments in this appeal, I would recast the Glaxo guidance as follows. And then we have, it is 13 points of guidance in the context of patent matters occurring in the Patents Court in the UK and the EPO in Germany, broadly Germany. First, the discretion, which is very wide indeed, should be exercised to achieve the balance of justice between the parties, having regard to all the relevant circumstances. So that's the key quote, the balance of justice, which is the thing that governs everything else. Two, the discretion is of the Patents Court, not of the Court of Appeal. That's slightly been sidestepped here because of the way in which I've put the case, that because the decision was based on the wrong basis, you need to exercise it afresh. Three, that's really to deal with the European Patent Convention and the 77 Patents Act, so it's not quite apposite here. Four, it should thus be remembered that the possibility of concurrent proceedings contesting the validity of a patent granted by the EPO is inherent in the system established by the EPC, European Patent Convention. It should also be remembered that national courts exercise exclusive jurisdiction on infringement issues. Broadly, that's the same here, and that's, you're looking at infringement here, and the European Union Intellectual Property Office looks at validity. Five, this is the main point against me. If there were no other factors, a stay of the national proceedings is the default option. Therefore, six, it is for the party resisting the grant of a stay, that's me, to show why it should not be granted. Ultimately, it is a question of where the balance of justice lies. So that reiterates paragraph 1. 7, one important factor affecting the exercise of the discretion is the extent to which refusal of a stay will irrevocably deprive a party of any part of the benefit which the concurrent jurisdiction of the EPO and the national courts is intended to confer. This was to deal with the Virgin problem, which occurred in the Supreme Court. The long and short of that was that if there had been a finding of infringement and the payment of money, then you might not be able to reverse that unless, and it says that in this last sentence of paragraph 7, it may, however, be possible to mitigate the effect of this factor by the offer of a suitable undertaking to repay. But that's not relevant here. 8, the Patents Court judge is entitled to refuse a stay of the national proceedings where the evidence is that some commercial certainty would be achieved at a considerably earlier date. So I rely upon both of those points, some commercial certainty, considerably earlier date, in the case of the UK proceedings than in the EPO. It is true that it will not be possible to obtain certainty everywhere until the EPO proceedings are finally resolved, but some certainty sooner rather than later and somewhere, such as in the UK, rather than nowhere, is in general preferable to continuing uncertainty everywhere. That's our core point, basically. And then just dealing with the last few points quickly, it is permissible to take into account the fact that resolution of the national proceedings, while not finally resolving everything, may, by deciding some important issues, promote settlement. We say that's also likely here. 10, an important factor affecting the discretion will be the length of time that it will take for the respective proceedings in the national court and in the EPO to reach a conclusion. It's not an independent factor that needs to be considered in conjunction with the prejudice which any party will suffer from the delay. 11, the public interest in dispelling the uncertainty surrounding the validity of monopoly rights. Patents, as you well know, are monopoly rights, but so are trademarks. You don't need to copy a trademark in order for liability to arise. 12, in weighing the balance, it is material to take into account the risk of wasted costs, but this factor will normally be outweighed by commercial factors concerned with early resolution. And then 13, this is just a general warning. The hearing of an application for a stay is not to become a mini-trial of the various factors affecting its grant or refusal. The parties' assertions need to be examined critically, but at a relatively high level of generality. So the factors there, which of course are not directly transferable across to this case, but you can get the gist of them, because patents and trademarks have certain things in akin, namely they're both monopoly rights, and also there are these parallel systems. For the patents, it's the Patents Court and the EPO, European Patent Office, and here it's the, well, IPEC, but it could be just the Chancery Division, and the EUIPO, the European Union Intellectual Property Office. It's really just for your note, but my Lord Justice Newey raised the point about whether or not you can deal with it now, if you were so minded. And there is some guidance to that, which is in the Global Torch case, which is in the authorities bundle behind tab 5. And it's paragraph 43 of that case on page 93. So authorities bundle tab 5, page 93. Paragraph 43, and it's by the letter D, capital D. As I have already indicated, case management and procedural issues should be determined by a first instance judge, and occasionally on appeal by the Court of Appeal, where they decide it is right not to send a matter back to a judge. I don't think that's contentious, but it gives you the sort of chapter and verse as to why I'm saying that you should look at it now. There's a general matter which I wish to bring to your attention, and that's in the authorities bundle behind tab 4, which is the KOP football case. And if you go to paragraph 51, which you may find on page 74, paragraph 51, page 54 behind tab 4, case management decisions are discretionary decisions. They often involve an attempt to find the least worst solution where parties have diametrically opposed interests. Well, I'm afraid that might be apposite here. There is no perfect solution. What I'm suggesting in my submission is the least worst solution. I would say by a long way, but so I would say that. Now, to make good that, this case is before IPEC, now wholly UK centred. So before IPEC, there are no EU elements at all. And that is because the EU trademark infringement matters have now fallen away completely. But to pick up on a point that my Lord Justice Newey said, there is still an EU bit here, and that is the invalidity that's still proceeding within the EUIPO at whatever stage and whatever level it might be. Now, that's always going to be there until that finally reaches a resolution. But that is concerned with the EU attack on validity of the Chevron Mark alone. So it deals with two issues, the Chevron Mark and validity. And that's it. Does not touch the Symfonie Mark. It doesn't touch anything else to do with that EU mark. And that's going to work its way up and down the various levels within the EU system. And so what's left before the IPEC is infringement of the UK comparable marks, the Symphony and the Chevron. So that's a UK matter. The revocation of the UK Chevron mark, the UK tort of passing off, and the various defences. Let me just go to the right place. So this is all set out in what is called our reply skeleton, which may be found in the core bundle behind tab 14. Starting at page 98, so core bundle, tab 14, starting at page 98. And so in addition to what I've already said, there's also, of course, the UK threats matter, which is how this whole thing started off. In paragraph 10, it lists 4 points, A, B, C, and D. It failed to list the revocation of the UK Chevron mark, but you can see that that's actually an issue when you read further on. In particular, if you pick it up under 11C, but I'll come to that in a minute. That was just an omission. So you have three options. There's no stay at all of anything. And this is analysed in paragraphs 8 and 9 of that skeleton. And the way in which we've done it is, if you have the hypothetical no stay, you look at the best option and the worst option. Under the worst option, there is a possibility of conflicting decisions between the EUIPO and the UK vis-a-vis the validity of the Chevron mark. My lords, I probably need to unpack that a little bit. Sorry, I've jumped ahead. If you have an EU mark and within the EU system it is declared invalid, that does not, sorry, that would then automatically affect the UK comparable of that mark. That's under the withdrawal agreement, articles 55 forward, going forward. However, if in the EU it's valid, that doesn't automatically mean that it's valid in the UK. Potentially, the UK could come to a different decision. I say potentially because the first decision would be persuasive. But anyway, treating all this on the worst case scenario, it's possible that if there were no stay at all, then there could be conflicting decisions on that issue.
I appreciate you're not arguing for this option. But nevertheless, forgive me for asking this question. Why does it matter? We do it all the time at patents.
The reason, my lord, is because the way in which I'm going to put it forward for this middle option is that it reduces the size of the case so that it clearly fits within the IPEC 2-day limit. And to unwrap that a little bit more is that if you are going to try and argue validity of the UK Chevron comparable mark, you're going to have to argue a number of things of some complexity before the IPEC, and that might take time. You can see that it's already taken some time within the European Union system because we're going up and down to the General Court twice we're on the second visit to the Grand Board of Appeal.
Yeah, but that's because of different conceptions of procedural economy. So,
Yeah.
in many civil law jurisdictions, the idea of procedural economy is you take the shortest route to a decision.
Yes.
And once you've decided it via the shortest route, you ignore everything else. But
Yes.
then that leaves the problem of what if you're wrong
Yes.
on that. Whereas, as you know, in this jurisdiction, we have a different philosophy, which is the court of first instance decides everything.
As much as this case, yes, exactly. It puts it all into overcooked comments, and then they can be raised in respondents' notices and what have you.
Although it can be difficult when sitting at first instance to anticipate all eventualities, as we see in this case.
My lord, you know that far better than I do. I'm glad I'm on this side of the bench. But that was an aside. So that's a possibility. My Lord Justice Arnold has, argued against me for saying that I should reject it, but I'm sticking by my guns. I'm saying that there is a possibility that it could be a bad solution. Going to what I say is also another bad solution is that there's a complete stay of everything. That's option 3, which is dealt with very briefly on page 100 at paragraphs 14 and 15. The reason I say there should be a complete stay of everything is a bad idea. It's basically delay. If you stay IPEC now, nothing happens in IPEC, and we have to wait upon the EUIPO. The 5 years that my Lord Justice Newey mentioned, that may be an underestimate, maybe an overestimate, but I don't think it's far wrong. And that's too long. Proceedings in IPEC generally take about a year from beginning to end. I mean, if things go as they ought to go. So its delay is the big reason why option 3, total stay, is bad. Now, why I say option 2 is the best option. It's a little bit of a halfway house, which is a partial stay, and this will deal in more detail with my Lord Justice Arnold's point, is what I'm suggesting is that in the IPEC case, we do not deal with the UK attack on the validity of the Chevron Mark. So we park that basically because of this potential contamination with, or cross-fertilization, whichever way you want to look at it, with the EUIPO's decision on that element. And so we leave that for another day. Now, I accept that is not neat. It's not perfectly neat. But it has the following advantages, we say. First, it means that absolutely everything else that is left is completely UK-centred without any possibility of interference from the EUIPO. You're left with UK trademark infringement, UK threats, UK passing off, and UK revocation of the Chevron Mark and the various defences. There's no EU element at all, not even a shadow of an EU element. And we can get on and deal with that now. And from now till the end of IPEC will be about a year, or give or take, plus the bits it takes for the matter to be resolved before your lordships. And that will give rise to certainty. Now you may say, well, it's not complete certainty. I accept that. But the two elements of outstanding uncertainty are small. One is the effect of the EU IPO's decisions on the validity of the EU Chevron Mark. That would be small. Normally, it would be highly persuasive and have a domino effect into the UK Chevron Mark. So there has to be an EU decision somewhere along the line, unless both parties just simply give up and go away. That's unlikely, but there's going to be an EU decision somewhere, and its effect is going to happen in many years' time, but it's going to be small by the time the dust has settled on the IPEC.
So just talk me through that. You say it's going to be small. So suppose you have your IPEC proceedings coming to a conclusion, and then in the fullness of time the EUIPO decides for validity or invalidity. That has an obvious impact, either necessarily or highly persuasively, on validity in the UK. Why is that a small effect?
Because broadly, you need a whole load of things to happen together in order for its effect to be material. Those are set out in paragraph 12 of the reply skeleton. Maybe I should go back one paragraph, and that is option 2, which is the partial stay, is discussed from paragraphs 10 onwards. Paragraph 11, in essence, says that there will be commercial certainty if certain of the decisions happen in paragraph 11. And you'll see that there's various options for, and they're all followed by or. So if there are decisions in certain ways, there are 4 different ways in which you can get basically commercial certainty. But it's a different consideration when you come to paragraph 12, which is, in order for it all to fall apart, we say, you actually need all 4 of the things detailed in paragraph 12 to occur. Not one of them, but all 4. So it reduces the probability. I'm afraid, my lord, it indicates again, this is not a perfect solution, and there is no certainty of certainty. But looking at the way in which things could work out, we say it's far more likely than not that commercial certainty will be reached. And that
Probability of certainty.
yes, I was trying to avoid that, but mine's now being wagged. Yes, exactly so. The point being is that then brings me to the next point, which is, even if you don't achieve complete certainty, I'm now on very thin ice, if you get any one of the 4 decisions that are outlined in paragraph 11, it's more than likely that that will precipitate a settlement. Remember that was mentioned in the IPCOM case? You might get enough certainty that the parties realistically will end the matter. Yes, you could fight on, but there's an element of cutting your losses.
I haven't shown that much inclination to settle so far.
That is absolutely true. That is absolutely true. You don't know and you don't want to know the details of general court matters, but hard fought is a fair characteristic. I was in them. But regardless of their lack of inclination to settle so far, reality eventually has to impinge, even on these parties, neither of whom are small. And you see, point being is that, I mean, as my Lord Justice Arnold described the latest round, it was a score draw. Well, that doesn't encourage either party really to give up, wave the white flag. But if, for example, against me, it was found that there's infringement, so my threats action falls, there is infringement, and the counterclaims that I'm running in IPEC fail, that would move the dial, in my submission, increase the probability that certainty could be achieved through settlement. I covered all the various bases. And you see, this leads back to the point that, yes, eventually there will be an EUIPO decision on the validity of the EU Chevron Mark, and that will have a knock-on effect on the validity of the UK Chevron Mark. But the point being is it might actually become redundant at that stage. And so even though formally there might need to be a second decision in the UK on that bit, because remember, I'm parking the validity of the UK Chevron Mark, that might not be worth the fight. Now, I can't say it's not going to be worth the fight, but what I am saying is that when the rest of the landscape has been cleared, so people know where they're standing, it might become apparent even to these parties that that is a fight that is no longer worth fighting. No guarantees either way, but it does reduce the probability that that second UK issue will take up court time. So the long and the short of all this is, in the words of IPCOM, you are introducing some certainty, and we say sufficient certainty that there will be a commercial realization of where the parties should be going if you adopt this process of the partial stay is to carve out that sort of faintly tainted EU bit, even though it's still UK. That allows it to dovetail nicely into the 2-day time limit for the IPEC. And against that is the indisputable delay that would occur if there were a stay of everything. So it's, in this way, we bring everything back to the UK. There's no the de minimis EU contamination. So I'm just reading all the various notes that my learned juniors sent to me.
And if we ended up thinking there was merit in what you're saying, how would you structure it? Do you say everything except for, or do you stay a particular part and not the rest? You see what I mean?
What is now in IPEC, we would only need to stay the UK attack upon the validity of the UK Chevron comparable mark. There are actually 3 parts to that under the Trademarks Act 1994, sections 3(1)A, B, and C. But it's all nicely separated in the pleadings. I can show you if you like, but it's...
So it would merely be a matter of drafting rather than any difficulty of conception?
No, conceptually, it's absolutely clear-cut. The reason for that is the words, seeking invalidity and revocation fundamentally mean different things, and the meaning is defined basically within the Act. So there's no ambiguity there.
Yep.
The infringement is self-evident, the threats are self-evident, the passing off is self-evident, the other defences are self-evident, and the revocations of the UK Chevron comparable mark is self-evident. It would be just carving out the invalidity attacks. It's all well defined. My Lord Justice Arnold hasn't disagreed with me yet. So I'm inclined to stop while the going's good. But my Lords, I mean, I've been going for just over an hour. My Lords, unless you have any further questions of me, I've really skated over some of the bits, I'm afraid, but particularly the details of the interaction of the systems, but I think there's enough.
That's very helpful. Thank you very much.
My Lords, thank you.
Mr. Hollingworth.
My Lords, I think we have come down to there being 3 points. The first is whether or not the landscape has changed. The second is whether or not the decision of some Judge Hacon was tainted, and then the third, if it is, what to do and whether or not your lordships should reevaluate or send back. Those, I think, are the three topics. And I propose to take them in that order. Just before I do so, standing back, there is no appeal against many of the judges, many of the parts of the learned judge's assessment. And I will show you these bits in a moment. But the judge formed the view that if Crafts were to succeed, the appellant were to succeed, its losses would be in the order of $7,000 per annum, so £5,000 or £6,000 a year. No other relevant damage had been identified, and he therefore, in his judgment, rejected the need for commercial certainty, given that Crafts had already delayed for 5 years, 5.5 years before issuing the claim. So there's no appeal against any of those parts, my lords. And there is also now no dispute that at least part of the proceedings should be stayed. My learned friend has just addressed you on that. And part of the reason that he says that is because we are in IPEC, where there is the 2-day limit. But also in IPEC particularly, there are questions of proportionality. And moreover, all case management decisions in IPEC are taken on the basis of a cost-benefit analysis. Now, against that background, in my submission, the outcome of this case is entirely unsurprising, and in fact, I would say it's correct. Now, well, that's just an overview. So can I turn to the first point? The suggestion that the landscape has changed as a result of the amendments or the discontinuance of the EU TMR elements. My submission, you won't be surprised to hear, is that it has not changed. The landscape remains the same. This case, my lords, has always been, and will always be, at least in part, about EU trademarks. And there's a reason for that. The case is about threats and events that occurred in 2015. In 2015, there were only EU trademarks. UK marks did not exist. And in the particulars of claim, it was affirmatively asserted that there was no infringement of those EU trademarks, and therefore the threats could never have been justified. And those particulars of claim were before the end of the implementation period, so there were only ever EU trademarks. So the core question, were the threats justified, has to be considered by reference to whether there was or was not infringement of the only marks that existed, the EU trademarks, in 2015. Now, the counterclaim, which came later for infringement, is, as my learned friend very fairly accepted, that's the normal expected response to a claim for threats. One doesn't merely say they were in principle justified, one naturally counterclaims for infringement. Now, that gave rise to some extremely complicated questions of jurisdiction as a result of this timing of this claim. It was really almost, well, it was a difficult question to deal with because the claim was issued in the 11th of December, shortly before the end of the implementation period. Ultimately, however, those complications about the timing of the claim and the counterclaim don't arise before your lordships today. We have accepted that the judgment was determined under Article 132 in a way which was not advanced before the judge. We recognise that he erred, and we took the pragmatic decision, having regard to the fact that this is a case in IPEC and proportionality, that we weren't going to file a respondent's notice and try and reopen all the arguments. And as a result, we've removed that aspect of the claim. But it hasn't altered the substantive issues in any way. Now, the statements of case, my lords, and I can show you some of these, but I wonder if in view of the time it's perhaps not worth doing so. But the statements of case, my lord, have always identified the marks in question as EU trademarks. That's how they were defined.
Well, yes and no, because they're replete with references to the UK marks as well. Moreover, since I'm asking you a question, let me ask you another question at the same time, which is, do you accept or dispute that the counterclaim for infringement covers the period from 2015 through to the present day? There is express pleading, as I read it, of infringing acts post the threats, alleged threats, and it's asserted to be a continuing infringement, giving a rise to a right to an injunction.
Yes, I do accept that, my lord, that there are infringements alleged. The way we put it, it sounds like your lordship has looked at the amended pleadings. The way we put it is that the defined term for the marks in question, for the purposes of the counterclaim, we are only alleging infringement of the UK marks.
Yeah, so the acts that are pleaded post-date 2015, but in terms of the way it's now framed, the effect of the amendment, as I see it, and you will correct me if I misunderstood, is that if you succeed, you will get relief from 31st December 2020 onwards.
The way I think it was intended to be put, my lord, was that the relief from then, because this court is not sitting as an EU trademark court, we cannot sue on the basis of the EU trademarks. So we are suing for infringement on the basis of the UK marks.
And they only came into existence on the 31st of December 2020 at 11 p.m.
Yes, my lord. Insofar as what happened before that is concerned, it's still relevant what the position was under the EU trademark regulation, because that is what we're relying upon for the purposes of the threats.
To be sure, but that's being relied on by way of shield, not sword. So when it comes to the threats claim, you say justified, because at the time the alleged threats were made,
Yes.
They would have infringed the EU trademarks.
Yes.
But, and you've explicitly pleaded that, and I don't have any difficulty with it. But one needs to differentiate between what you plead by way of a defence to the threats claim and what you are pleading by way of counterclaim,
Yes.
seeking relief for infringement.
Yes.
And just focusing on the latter element, do you dissent, having had a chance to think about it for a minute at any rate, from the proposition that the relief can only be post 31st December 2020?
I certainly see the force of what your lordship is putting to me. I feel I would need to consider it before I give a definite answer to that, but I certainly see the force of what your lordship is saying. That's a question which, in my submission, doesn't actually affect whether the landscape has changed, given that.
Well, why not? Because before the amendment, if you succeeded, you would have had relief for all time periods.
Well, certainly, my lord, that was well, the basis upon which the judge made his decision to stay the case, my lord, was premised fundamentally on the fact that the fate of the EU mark would determine the fate of the UK mark. So, if I can put it this way, my lord, for the purposes of considering whether or not it was appropriate to grant a stay, there were registered rights in the Chevron Mark, unregistered rights in the Chevron Mark, and registered rights in the Symfonie Mark. And the exact wrapper within which the registered rights in the Chevron Mark existed didn't matter for the purposes of the decision, because whether or not they were UK marks or EU marks or both, they would stand or fall on the basis of the EUIPO's decision. So the effect that the EUIPO's decision had on the issues in this case, will have on the issues in this case, remain the same in my submission. Certainly, it doesn't affect the underlying factual issues or the underlying legal issues that need to be decided. The EUIPO decision will cause the registered rights in the Chevron Mark, whether they're EU trademarks or UK marks, to be determined. And because it will have that effect, the judge took the view that it was sensible to stay the proceedings until that outcome was known. So that, my Lord, is why I say, whilst I take my Lord Justice Arnold's points, insofar as the decision was concerned, it doesn't affect the basis of the decision, namely that the EUIPO decision would resolve those matters, irrespective of whether the marks were UK or EU marks. The question of what relief might ultimately be granted if and when either side prevailed was not a factor in the question of what relief, whether to grant a stay in my submission. So, my Lord, I think if I move to the second point, which is whether or not the decision was tainted, and I hope that by showing you the decision, that may perhaps shore up some of the submissions that I've just been making, to the effect that the outcome would have been the same in my submission, irrespective of whether simply EU marks, UK only marks were being considered, or whether UK trademarks and EU marks were in play. So, my Lords, the grounds of appeal, which can be found in the core bundle, it's behind tab 1, page 16. So we're concerned here with paragraphs 3 and 4. 3 is the ground of appeal that irrelevant matters were taken into account. And 4 consists really of two aspects. First, it said that the judge didn't consider whether he would have granted a stay irrespective of the EU TMR provisions. And then the second sort of subpart of that is that he gave no reasons. So those are the grounds for saying that his decision was flawed. In summary, our position is that when one considers the judgments as a whole, the main and the supplementary judgments, it's clear that he did consider the position, whether he would have stayed the whole claim, irrespective of the EU TMR position. And it is in our submission clear that the outcome would have been the same, with or without Article 132. And it is also our submission that the reasons that he gave for reaching that conclusion are clear enough. Perhaps, my Lords, I can accelerate these submissions by reference to my skeleton argument. which your lordships have in the core bundle behind tab 13. And it starts at page 84. If one turns on, please, to page 86, just looking at paragraph 11, the point there is made that KnitPro, we applied for a stay, and it was always on the alternative bases. It was under Article 132 and/or under the case management provisions. And it's pointed out at the end of that paragraph 11 that Mr. Brown's statement in support made it clear that the stay on case management grounds was sought irrespective of the applicability of Article 132. So it was always before the judge. So the question then is, how did the judge deal with it? And if I could ask you please to turn on in that skeleton to page 88 of the bundle, so internal page 5. There's a heading there, grounds 3 and 4, stay on case management grounds. Your lordships have been shown the applicable principles from the ABP case. I don't propose to take your lordships to it again, but just for your lordships' note, you were shown paragraph 21 of that ABP technology case. The following paragraph over the page makes clear the obvious but important point that when the Court of Appeal is considering an appeal in relation to a case management decision, it is exercising a review power. And this is a point that I'm going to come on to in due course as to what, in my submission, the appropriate course for this court to take would be. It is a review.
Now, what do you say the implication of that is?
What I say, my lord, is that if your lordships come to the view that the decision can't stand, it is, in my submission, open to your lordships to say, well, within the context of reviewing the decision, one can take account of the matters that are not the subject of an appeal. And in reviewing the decision, if you take the view that, notwithstanding the parts that weren't appealed, the decision, the part of it which was tainted, taking all that into the round, on a review basis, the decision should be set aside and you will say the case should not be stayed. In principle, of course, I accept that's open to your lordships. What I don't accept, my lord, is the position which I think is being put forward by the other side, which is, if it is shown that an irrelevant factor was taken into account, you effectively tear up the decision and start again. That, my lords, would be a rehearing. Now, I'm suggesting that this shouldn't be particularly controversial. There are those parts which are not the subject of appeal, and I have in mind my Lord Justice Arnold's recent decision from last week in the Iconics and Umbro case, in which it was held that the judge in that case had made errors in evaluating a likelihood of confusion, and so the matter needed to be reconsidered. But because there was no challenge by either sides to a number of factors, such as the level of attention of the consumers or the similarity of goods, then the Court of Appeal proceeded on the basis of those findings. So what I'm saying, my lords, is that there are unappealed findings, the ones I mentioned at the beginning. The fact that there is no, the losses are small, there's no real need for commercial certainty. Since those are not the subject of appeal, I would say that that has to form part of the background against which your lordships would review the decision. What my learned friend appears to be saying is, no. If the decision was tainted, it needs to be exercised afresh. That's what I've called metaphorically tearing up the judgment. In those circumstances, I would submit that the appropriate course is to remit the matter. Now, this was going to be my third point, but while we're talking about it, I can deal with it now. It is effectively a rehearing. My learned friends showed your lordships the global torch case, which of course recognises that the Court of Appeal may, in an appropriate circumstance, proceed on that basis. But the important words in that decision that you were showing were occasionally. It's not the norm. Occasionally, the Court of Appeal may exercise a case management decision. My learned friend in his submissions said the reason that he urged your lordship to do it now was on the basis of proportionality. He said, we're here now, we might as well do it. My submission, that's not a good reason. The proportionate way is to remit it because it is a decision which is a case management decision. That's what we're talking about now, a case management decision. It was heard as part of the case management conference. And that is the environment within which it is appropriate to make a decision on a cost-benefit basis. So there are two particular reasons why I would urge your lordships not to make the decision here. The first is that, with respect, your lordships don't have all the materials. That these bundles were not put together on the basis of a rehearing, put together on the basis of a review. Your lordships don't have the exhibits to the witness statements that were relied upon. And you don't have the other case management materials that were before the court. In particular, a list of issues, which was agreed between the parties and which is specifically relied upon in Mr. Carver's evidence in support. In his fifth witness statement, he refers to it in paragraph 14. And there were also case management directions that were largely agreed. All of those materials were before IPAC, and in my submission, if it is necessary for a fresh decision to be taken, that is the context within which it should be taken as part of the overall case management and on a cost-benefit basis.
This all assumes we get to this point.
Indeed.
So we'll assume for a moment we do get to that point. There is an attraction in what Mr. Edenborough is saying, in the sense that you don't want an additional hearing if one can be avoided. That just puts the parties to more expense. So what would it really be that we would not be in a position to take into account on a proper basis that Judge Hacon could take into account? I mean, you say there's a list of issues. Well, one can work out what the issues are from looking at the pleadings. You say we haven't got the exhibits, but what would there have been in the exhibits that could make a material difference?
Well, I think the exhibits were providing the background. There was correspondence explaining where we got to and why the proceedings had got to where they were. Yes, your lordships could, as it were, reconstruct list of issues, but as I say, it's archetypally, and I say this with respect, it is a matter for the IPEC judge making a cost-benefit analysis to decide how to regulate their procedure, how to fit everything proportionately into a two-day hearing. It's a matter of some surprise to practitioners who don't appear in the IPEC frequently that it is open to the IPEC to say, well, I understand that there is a point on the pleaded case, but even though I can't say it's unarguable, I'm nevertheless not going to allow you to run it because it doesn't fulfill the cost-benefit test. Now, of course, I'm not suggesting the lordships aren't capable of doing that, but that is the framework within which, in my submission, the application for a stay should be considered. And it's something which, in my submission, whilst one could sort of reconstitute materials, when you don't have a list of issues, you don't have sight of what the directions were and the exhibits for what they're worth, it is more appropriate for it to be dealt with in IPEC. But the second reason why I would say, in this case, it is more appropriate for it to be remitted is because if one is going beyond reviewing the case and reviewing the decision as it was taken on the date that it was taken, and if one actually says, well, we should be evaluating matters afresh, we should, in those circumstances, actually be considering what matters have moved on, including, as my Lord Justice Arnold pointed out, the recent decision of the Grand Board of Appeal in this very case. And the parties should, in my submission, have an opportunity to make their submissions about that and effectively re-argue the case in the light of developments and having regard to the cost-benefit test in IPAC, and remitting the matter would have the effect not only of being able to take the decision of the Grand Board of Appeal into account, but also of, by then, presumably knowing whether either or both parties has appealed that decision. Lords, if I may just, if that's dealt with your Lordship's questions about that aspect, if I may revert to the question of the judge's decision and whether or not he actually, it was tainted in the ways that are suggested. And I was looking at my skeleton argument, which is on page 88 of the core bundle. And I don't think I need to go through the parts of the law that I've set out. If I could pick it up, please, at paragraph 26. I'm making the point here that when the learned judge refused permission to appeal, the reason that he refused permission was that although the points on Article 132 warranted consideration by the Court of Appeal, I've set it out in the italicised text, he took the view that that was academic in that a stay would anyway have been granted as a matter of case management. The word anyway is crucial in my submission there. I haven't actually included the reference to the bundle there. I don't need to show it to you, but it's tab 7 of the core bundle. His reasons for refusing permission to appeal. The use of that word anyway in my submission makes it clear that irrespective of the position under Article 132, he would have granted the stay as a matter of case management. The position then becomes even clearer when one takes into account the supplementary judgment, which I set out in paragraph 28 of that same skeleton argument. I'm not detecting any resistance to the proposition that it is permissible to take that supplementary judgment into account. I've cited in my skeleton argument in the preceding paragraph the Greenwich Millennium Village case, which confirms that.
I have to say I was grateful to be reminded of this because I was aware of some such decision and looking for it the other day and couldn't locate it. So I'm glad to be reminded of the reference to it.
Good. Well, I'm glad to hear that. I think, in fact, my lords, it's clear from the English and Emery-Reinbold case itself, where the notion of inviting the judge to give, as it was put in that case, an affidavit for taking into account, and indeed in that English and Reinbold Emery case, an addendum to a judgment formed a very important part of the reasoning as to why the appeal was not allowed. So I'm proceeding in the absence of any objection from my learned friends that certainly the supplementary judgment can be taken into account. And one has to read them as a whole. And I've set it out in paragraph 28 that, and I don't need to read it out, I've highlighted the points. He's making the point that the reasons that he gave apply to all of the claims before the court, including those which, on his analysis, he was obliged to stay. And in the second of those paragraphs, the issues are swept up in his decision on case management grounds. So, as I've said in paragraph 39, in my submission, and this is responding to ground 4 of the grounds of appeal, it is clear in my submission he did consider and he did hold that a stay would have been granted, irrespective of the position under Article 132. The question of whether or not the reasons he gave were adequate or whether he was right to do so is a separate point, which I'll come on to, but he did consider it, my lords. Now, in my skeleton, I've set out why it is that I say the other factors make it clear that he did consider it and it wouldn't have made a difference, but rather than going through my skeleton, I would propose to turn to the judgment, if I may. So I think that we can put the skeleton aside and turn, please, to the main judgment, which is behind tab 5. And the position on the case management stay starts on page 47. But it is, in my submission, necessary to sort of understand the architecture of this judgment before we get into the detail of it. So if we start at paragraph 56, we see from the last sentence, starting at the end of the third line, that he's already made the decision to stay various things: the counterclaim for infringement of the EU Chevron Mark, claim for threats in relation to the EU Chevron Mark, and the claim for revocation and the declaration of invalidity in relation to the EU Chevron Mark. So all those EU Chevron claims he's already decided to stay. So he then comes to consider, from a case management basis, everything else. Now, the first part of the decision, which is paragraphs 59. In fact, before I look at it, can I just make a further point? 59 to 71, and we'll look at them in more detail, but that whole chunk is considering the UK Chevron Mark. It's focused on the UK Chevron Mark. And then it's the last paragraph that deals with the other issues. So the focus, I don't say exclusively, but the focus of those paragraphs, 59 to 71, is on the UK Chevron Mark. And he starts in paragraphs 59 to 62, considering what the effect of the EUIPO proceedings on that mark is. And he sets out in 59 and 60 the provisions which mandate that if the EUIPO proceedings result in cancellation of the EU mark, the UK mark must fall as well. So there is no dispute, and it's recorded in 51, paragraph 61, the end of 61, if the EU Chevron Mark is declared invalid by the EUIPO, the UK Chevron Mark will also be invalid. But 62 is important because although he recognises that the reverse is not necessarily the case because it's not provided for in the legislation, he records the submission that I made that it would be an abuse of process for Crafts to seek a declaration of invalidity of the UK mark if it had already been raised in the EUIPO. As I put in the skeleton, that appears to be an approach that found favour with Mrs. Justice Bacon in the recent case, but he said he doesn't need to decide that because, and I'm about halfway through, it is safe for me to assume that this court is unlikely to reach a different view on the validity of the registration of the UK mark to that reached by the EU tribunals. An important point, which is not...
Can I just ask about that? Because I'm a bit puzzled by that, because it's everyday experience that courts in this jurisdiction reach different decisions to the boards of appeal of the European Patent Office with regard to the validity of the same patents. So it's common, and it's not even regarded as particularly surprising or problematic. Why should this be different? And let me give a specific instance. So far, EUIPO has not made any decision as to acquired distinctiveness of the Chevron mark. And we know, because it's happened in other cases, that one thing that is very possible with regard to that issue is that different decisions will be reached in this court and in EUIPO because the parties, for whatever reason, choose to file different evidence. There have been quite a number of cases where that's happened. So how can we assume that the same won't happen here?
Well, my lords, there are, the grounds of appeal are 71A and 71B. These are...
Yeah, well, just that irritates me. Forgive me. This is irrelevant, but I can't help saying it. The General Court has told you twice that that's the wrong legal regime. It's not the 2017 regulation that is applicable. It's the 2009 regulation. So the article numbers are different.
Well, I apologise.
For procedural issues, yes, of course, you're under the later regulation, but for the substantive issues, it's the earlier one. But anyway, that's that. Rant aside.
I apologise, my lord.
Which isn't directed so much at you as everybody,
Well, thank you for clarifying that.
including in particular the judge.
Yes, well,
But it doesn't matter. That doesn't matter. That's a distraction.
yes. So, my lords, the position is that I accept that it is possible that certainly on an acquired distinctiveness position, there can be different evidence and there can be a different outcome. The situation so far as the underlying aspects, whether or not the mark is properly to be regarded as a trademark under the, let's call it neutrally, the A provision, whether it's got adequate distinctive character under the B provision, those are issues which are, those are matters which are in issue between the same parties. And I do stand by the submission that on the basis of the judgment that I mentioned, the Easy Group and Nuclei case, it is capable, I put it no higher than that, of being an abusive process for the same parties to try and re-argue matters. And essentially, I come back to the point, my lord, there is no appeal against this paragraph. The judge has come to the view that he thinks that the outcome of the UK mark is likely to be determined by the outcome of the EU Chevron Mark. He uses the word unlikely, so it's leaving open the possibility that there could be arguments as to whether or not a different conclusion should follow, but he's proceeding on the basis that they will stand or fall together. And he goes on to make the point that
Was the judge aware of the fact that certainly in EUIPO, and I think my reading of the pleadings is certainly the case here, but I'm not sure whether he was necessarily aware that there was acquired distinctiveness was a live issue, because as matters then stood, everybody was ding-donging about A and B, whereas what is now Article 7.3 doesn't seem to have been referred to.
I don't think it featured in skeleton arguments. I certainly had it in my mind. I'm afraid I can't recall, to be honest, my lord, off the top of my head, to what extent, if at all, that was a topic of the argument. There wasn't a transcript in IPEC. It was certainly on our radar, as it were. But I can't answer the question.
I think my question is more to this effect. Can one discern from the judgment that the judge was aware of that?
No, I don't think one can, my lord. It's neutral on the point, I would say.
Okay.
Well, so my submission up to this point is that he is proceeding on the basis, and there is no appeal from the fact that he's proceeding on the basis that the UK mark would stand or fall with the EU Chevron mark. And that is why in my submission I say that the removal of the counterclaim for infringement of the EU mark has not materially changed the landscape, because the effect that the EU decision will have on the issues in this case remains materially the same, regardless of what the nature of the registered rights in the Chevron mark is, whether it's the UK Chevron mark or the EU Chevron mark. He then goes on in the next part from paragraphs 63 to 65 to consider the EUIPO guidance, which your lordships were shown. I don't think I need to say anything more about those. And at paragraph 65, sorry, I'm sorry, there are two paragraphs 65, I've just noticed confusion.
Yes.
Can I just pause actually at the end of 64 before I come on to the 65s? The point he makes at the end of 64 is that if the EU Chevron mark is found to be invalid, so will the UK Chevron mark, and infringement and revocation for non-use fall away. of the Chevron issues, only the question of whether there was a threat on the facts would remain. So he's recognising there the procedural benefits, because if the EU Chevron Mark is found to be invalid, large issues fall away. He then sets out the IPCOM guidance, and in the second numbered 65, so I'm looking on page 52, he there is saying, he's considering the timescale. He has taken the 5 years estimate from the evidence of crafts, so that's what they were putting forward, and he's accepted it, so it can't be disputed. And he points out, well, that's probably a maximum, but I'll assume it's correct. There's an interesting point he makes 2 lines down. If there were no stay of the present proceedings, the issues relating to the UK Chevron Mark and the EU Chevron Mark, if this court has jurisdiction, would be decided in about 9 to 10 months. So that may be an indication, read in the light of his supplementary judgment, that this case management stay certainly did not depend upon the EU court having jurisdiction over the EU trademarks, because he's recognising there is an issue as to whether it does or does not. He then, in paragraphs 60 onwards, considers Craft's evidence as to its losses and whether there's any urgency, and this is the point that I made at the start. In paragraph 67, he says that the evidence about damages is hard to follow, and he does his calculations on the basis of the evidence, and the figure that I gave is about 7-8 lines down towards the end, $7,200 a year, and therefore, even if the case was stayed, the total losses would be in the order of $122,000, translated into about £97,000. There's no prospect of Crafts losing out because of a damages cap. Losses elsewhere will be dealt with elsewhere if there are any proceedings there. And then in paragraph 68, he goes on to make the point that there was a delay of 5.5 years between the alleged threat and the institution of these proceedings. And he goes on in 69 to say, in the second line, if Crafts had been seriously concerned by irreparable damage due to the takedown notices, it seems to me that it would have issued a claim form in 2015 and would have either sought interim relief or moved the case forward to trial. Its behaviour is more consistent with a willingness to live with a loss of any sales and to claim compensation in due course. And he makes the point that they were protected under the Limitation Act. 70, it will be compensated and no other relevant damage has been identified. So again, my lords, there's no appeal against those provisions. He's rejected the suggestion that there is a need for commercial certainty.
Well, where does he discuss commercial certainty for your clients on their counterclaim? Because your clients say their trademarks have been infringed.
Yes,
and they want the usual relief that follows from finding infringement, an injunction, delivery up, damages or on account of profits.
Yes, my lord.
And that might be thought to be of some importance to a trademark proprietor. And it might be thought the trademark proprietor would want to know, yes or no, have my trademarks been infringed? Do I get the relief that I've asked for?
Well, indeed, my lord, but equally, it is
where is that discussed?
I'm sorry, my lord?
Sorry, where is that discussed?
It's not discussed, my lord, because it was not raised before the judge as being a reason for KnitPro wanting to proceed with the case. The position, my lord, is that you've heard there are hard-fought proceedings going on in the EUIPO. My learned friend has more experience of them than I have, but they're hard-fought. These are relatively modest businesses, and the preference of KnitPro is that having fought the case up and down in the EUIPO, it would rather only have to fight on one front, and that is why, my lords, it has said that this claim should be stayed. So
Right.
that
Well, that's helpful. So you've just explained why it is, from your client's perspective, commercial certainty on the counterclaim is not the driving consideration. I understand what you say about that, but why is that the end of the story? Because there's a defendant to the counterclaim.
yes, well,
And why does the defendant to the counterclaim not equally need to know, are they infringing or not? Are they going to be subject to an injunction? Are they going to have to pay you your client's damages?
well, my lords, of course that's a factor, and that's what they say. That is indeed what their evidence is. They want to know that. Commercial certainty is something he was plainly aware of because it's part of the IPCOM factors. And in my submission, that is what he is addressing in the paragraphs that I have just identified. And he is saying that they don't. If they really had a need for that commercial certainty, they would have done something much earlier.
I don't understand that, because the counterclaim was not in existence at that stage. What he's pointing to, and one can quite understand the force of the point that you were making and which the judge has accepted, namely, here you've got a party, crafts, claiming that they're suffering irreparable harm. Let's test that by what they actually did. Answer, they stood on their hands for a very long period of time indeed, and did nothing. And the judge says, well, that gives the lie to the idea that they were suffering irreparable harm due to the threats. But that's their claim.
Yes.
It's not your claim against them.
Well, yes, my lord, but as a matter of practicality, our claim against them, it's not suggested it has caused any different behaviour, as it were. That their position is that as a result of the threats, they have effectively stopped selling, and it's therefore not suggested that anything different has occurred as a result of the natural counterclaim for infringement to make good the suggestion that the threats were and remain valid. So,
I'm sorry, I'm not understanding that. Forgive me if I've misunderstood. But the irreparable harm he's discussing here is the alleged loss, I emphasise alleged loss, by crafts selling through Amazon UK.
yes.
But I understand it to be common ground on the pleadings that crafts were selling in parallel through other channels. And that's part of a key part of your infringement counterclaim.
Well,
That's why you've got the claim that extends through to the present day. It's precisely because, although you were successful in stopping them selling via Amazon UK through the notice and takedown procedure, they carried on through other channels.
Well, my lord, this is a point of contention between the parties as to whether they did or not.
Right.
And
You're alleging that they did, and you're suing them for it.
Well, in circumstances where we're bringing a counterclaim, we're saying we want to bring in any sales that have been made, and the response to that was, as I recall, well, actually, I'm just seeing if I can find it, my lords, on the pleadings.
Yeah, so you plead, for example, sales through knitpicks, greatbritishyarns.co.uk and fishbond.uk.
Yes.
I mean, there may well be others, but I mean, that's just what I've alighted upon immediately. And you also plead Amazon.com, which is what Amazon likes to call Amazon US, although in fact it sells all around the world.
Indeed. So far as Amazon US is concerned, it is said that it is that there are some withdrawn products sold on Amazon US, and this is in paragraph 10 of its reply, but this is where it appears that there is a dispute between the parties as to the extent to which they are being sold in the UK. But I think having looked at the pleadings, I accept what your lordship is putting to me.
Sorry, paragraph 39, which is what I was just reading from, is omitted.
Yes.
So they admit, for example, sales through nitpicks, Great British Yarns, and Fish Pond.
Yes, I'm just checking the evidence, my lord. So yes, I accept that it is broader than just the amnesty. And I accept, therefore, that that's not a point which the judge has addressed, but equally, it's not a point in my submission that he was asked to address on the basis of the evidence before him. So it wishes to have some commercial certainty about that, and it's not a point that's addressed in the judgment. I accept that. But he does accept that the delay is something which is a factor to be taken into account. So I don't think I can say any more about that, my lord.
Thank you.
Now 71, my lord, paragraph 71 is the only part of this entire judgment that actually is in any way referring to Article 132. Nowhere else in this part about case management is he linking his findings to the position under Article 132. I accept that in that first sentence of paragraph 71 he does, but the point here, my lord, is that the same position arises now in circumstances where Crafts accepts that at least part of the claim has to be stayed. So it applies mutatis mutandis. One could read that paragraph, as I've set out in my skeleton argument, as if there is no stay of all of the claims, there will be a trial in several months' time and a second trial after the judgment of the CJEU to deal with, rather than the claims that the court is required to stay, the claims which Crafts agree should be stayed. So the fact that there is a two-stage process is still the case, irrespective of whether or not the reason for the two-stage process is Article 132 or the acceptance by Crafts that part of the case needs to be stayed. And the second part of that paragraph applies irrespective. A judgment in relation to the Chevron claims in this court will at least in part be subsequently overtaken by the CJEU's judgment, possibly in substantial part. So the cost of dealing with such claims in this court would be wasted. So again, in my submission, he's clearly got the cost benefit in mind, and he's saying that we're going to end up potentially wasting a lot of time and money in IPEC in circumstances where the proceedings in the EUIPO may result in a substantial part of that being wasted. Now, in paragraph 72, he concludes this by saying, I take the view that the balance of justice favours a stay of all claims relating to the EU and UK Chevron marks. So he is, whilst he has been focusing on the UK mark and the effect that the EUIPO proceedings will have on that, he's here using the language of the case management stay, the balance of justice, as favouring a stay of all claims for both the EU and the UK marks. And then in paragraph 73, he applies essentially the same reasoning to the rest of the claims. It's just not a good idea to have two separate sets of proceedings, and so the other parts of the claim should be stayed as well. So I would say, my lord, that to the extent that Article 132 features, it is clear in the light of this judgment and his supplementary judgment that it did not form a material part of his reasoning to stay on case management grounds. Put it another way, it had no weight in the various factors that he weighed up. I also say, my lord, this is not a lack of reasons case. One can discern his reasons, except there may be argument about whether they're right, and my submission is they are, but it's not a lack of reasons case. So well, that's the judgment. And just pausing, I say that it is clear that he did consider whether he would have stayed the case anyway, and that it's clear that he would have done, and on that basis that the appeal should be dismissed. Now, if your lordships are against me on that, then the question of what to do arises, and I've already addressed some of these aspects of it. My submission is that, for the reasons I've advanced, if you consider that the decision can't stand, either because the position has moved on or because it was tainted, I do say that it should be remitted for the reasons I advanced earlier, and I don't think I need to repeat those. But I finally need to consider the position of, well, if your lordships were minded to consider it now, what should your lordships do? Now, the learned friend has referred to his reply skeleton, which can be found behind tab 14 of the core bundle. And at pages 98 onwards, there are the three options. Now, my lords, there have been a variety of options and possibilities put forward, first instance and on appeal. The judge considered various permutations that were put forward in the skeleton arguments before him. They've now been recast as options 1 to 3. My overall submission, my lord, is that it is fruitless, or at least it's very risky, to try and embark upon an assessment of what all the possible options are, far less to try and work out what's more likely than not. It's clear from the IPCOM case and elsewhere, and this shouldn't be a mini trial, we shouldn't be looking at the merits of the case. It's all very well saying, well, it's more likely that this will happen because all of those things need to have occurred for the opposite to happen. But one is getting dangerous and close there to trying to guess the outcome in weighing up what is more likely to be a position in a few months' time. And I say that's a risky course to adopt. It's rather like the treacherous shortcuts in preliminary issues. Anyway, the suggestion now is no one is contending for option 1. So there's going to be a stay of something. My learned friends advocate option 2. Now, what is notable in their option 2 scenario, all of those possible outcomes that your lordships were shown in paragraphs 11 and 12 and 13, none of them require or even consider a determination of infringement of the Chevron Mark. All of those would apply equally if the Chevron Mark questions of invalidity as well as questions of infringement as well as invalidity were stayed. They are simply focusing on the fact that they might get some commercial certainty from knowing whether or not was passing off or infringement of the Symphony Mark.
I may have misunderstood the point you're making, but why does it not assist crafts if they get a finding that there is no infringement of the Chevron mark, even if valid?
I agree that might assist them, but my lords, that is one of a number of possible outcomes, and it's not one of the possible outcomes which, as I understand it, is being put forward in these various hypothetical outcomes that they're contemplating. I accept that in relation to the Chevron aspect, could help, but it, as my learned friends accepted, there is no way of knowing how likely that is. And equally, if there is a finding of infringement, the consequence of that won't then be known until finally we get the decision of the EUIPO, because my learned friends accept that that part should be stayed. So I do say, my lords, that this menu of possible outcomes and permutations is a risky approach and not the appropriate approach to adopt. And I would just conclude, my lord, by saying that the much more fundamental points, of which there are, I suppose, two, the Chevron mark, my lord, has always been at the heart of this dispute. It is the broader of the marks. As you've seen, the Symphony Mark is shown in colour. No doubt that's why crafts chose to challenge it. And there are many more issues in relation to the Chevron mark than there are in relation to the Symphony Mark. So it is challenged on grounds of invalidity and non-use, whereas there's no challenge to the Symphony Mark. It's relied upon for infringement under each of the sections, 10.1, 10.2 and 10.3. And it is relied upon in relation to both lines of products, the Caspian and the Sunstruck products. Whereas in contrast, the Symphony Mark is only relied upon in relation to one of the products, the Caspian products, and only under sections 10.2 and 10.3. So if the Chevron mark is held invalid, all of those issues will disappear. And it leaves a much smaller subset of matters to be resolved. And determining them in the meantime will have been a waste of time and costs, which is exactly what the judge recognised.
I mean, obviously, there's a potential for time and money to be wasted, whichever route one takes.
Well, my lords, it's accepted that the EUIPO proceedings have to run their course. Everyone acknowledges that's going to happen.
Even one possibility Mr. Edenborough mentions is settlement. I mean, if there was settlement, they wouldn't have to run their course.
Well, as your lordship noted, that doesn't appear to have been the case thus far.
No.
It is possible. But absent that, the EUIPO proceedings will have to go ahead.
Yes.
If the EUIPO proceedings go ahead, they may, if they invalidate the mark, make the UK proceedings a lot simpler. If they don't invalidate the mark, the judge was of the view that they were likely to inform. It is unlikely, he said, that the UK court would come to a different view. So they will still shorten the UK proceedings.
Of course, it might lengthen them because you have arguments over whether A, there might be an abusive process, or B, if it isn't an abusive process, what the status of the EU decision is in terms of how persuasive it is.
That is, of course, possible, but equally those are matters which could be dealt with on a case management conference basis when there is a list of issues and the judge takes the view as to what it is proportionate, what the cost-benefit analysis should allow to be argued. And it's entirely possible that on a cost-benefit analysis, in circumstances where, let's say, acquired distinctiveness has been considered and it is found by the EUIPO that there has been widespread use of the mark, including in the United Kingdom, that is then something which the IPEC judge could take the view, well, it's just not appropriate to reopen that point in the UK proceedings. And many of those issues of use and acquired distinctiveness could potentially have a bearing on issues in this case, including whether there's goodwill in the United Kingdom, whether there's a reputation for the purposes of extended protection. So it does have the potential to have effects beyond merely the binary outcome of yes or no, whether or not the mark is valid.
Which may take me to another point. You refer to the preliminary issue cases where, as you say, there are warnings about treacherous shortcuts. And one problem you get with preliminary issues is it turns out that the preliminary issue can't properly be isolated. There's a relationship with other things that aren't now being determined. Now, is that suggested here?
Well, I accept that in point of law, there is a distinction between what my learned friend is agreeing must be stayed. Just to be clear on that, my lord, it's in his grounds of appeal in the appellant's notice. So it's behind tab 1 of the core bundle. On page 8. So in the section 9 of the ground of the appeal form, there is the order that he's seeking. The invalidity counterclaim of the UK comparable mark is stayed pending final resolution of the application made in the EUIPO.
Yes.
So that's what he's asking for, and I accept that in point of law that is, it's clear what we mean by that. But his reason for accepting that is that he recognises the undesirability of judgments which are hard to reconcile. And the point that I was just discussing with my lord was the potential for inconsistencies between other aspects of the judgment. And of course, I take my Lord Justice Arnold's point that that's inherent and that can happen. But in circumstances where there is going to be a stay of that part to try and avoid that, it is not in my submission that a desirable course that you could have a situation in which the EUIPO considers evidence of acquired distinctiveness and comes to the view that there has been no use shown in the UK, and for the UK, meanwhile, to be coming to a view about, yes, there has been use shown and there's goodwill and there's reputation and so on and so forth. So if one is going down the route of staying this aspect, my submission is that it makes more sense to stay the whole of the case and deal with it then once the outcome is known, than it does to try and slice it up in the way that's being suggested here. If I could just check that I haven't missed it. Yes, unless your lordships have any further questions for me.
Can I just ask this? You very helpfully at the outset identified that you were going to take the points on the 3 heads.
Yes.
In fact, you then took the 3rd head slightly ahead of when you were planning to.
Yes, my lord.
To do so. So I reserved asking the question in case you came back to it. I don't think you have in this way. You indicated that if we get to the 3rd point, what to do, your submission is that the case should be remitted to the IPEC. And the first point you made was that here we don't have all the relevant materials, including the exhibits to the statements and so on. My Lord Justice Newey effectively asked, well, what would that tell us that we need to know? And you've answered that question very helpfully, thank you. You then went on to say that we would need to consider new events, including, in particular, the recent decision of the Grand Board in the EUIPO process. Now, it's been explained to us already what the lengthy process of potential appeal is in that quarter. Why would the IPEC judge be in a better position to consider that aspect than us?
Well, my Lord Justice Arnold has very helpfully indicated that he's seen a copy of it. It's not something that we have thus far made submissions on the basis of. We have come here before your Lordships today on the basis of there being a review of the existing decision. What we're now contemplating, my Lord, is effectively a rehearing. And if there is to be a rehearing, then the question of what should be taken into account and where and by whom. And whilst, of course, I accept in principle that your Lordships could take that into account, it's not something that either party has addressed their submissions to thus far on how that might affect the outcome. And the second point is a timing point, just as a matter of practicality. Unless your Lordships wish to reserve judgment until it's known whether whether there will be an appeal, the likelihood is that, as was explored between my learned friend and my Lord Justice Arnold, that will probably not be known by the time that your Lordships otherwise give a judgment. So I think the answers are those twofold, the second of which is a purely practical timing point.
Well, can I just pursue that just slightly further? Because at the moment, it's difficult, so as far as I can see, to see what relevance the Grand Board's decision has beyond confirming that the resolution of the EUIPO proceedings is liable to take 5 years, possibly less, possibly even more, because it's just simply another step in an already rather convoluted process. And what one sees from that is current state of play, subject to appeals, is it goes back to the cancellation division. But why does any of that alter the basic proposition which the judge proceeded on the strength of, namely, you've got a somewhat indeterminate period for resolution of the EUIPO cancellation action. Best estimate 5 years, could be less, could be more.
Well, of course, in principle, I can't disagree with that, other than to say that we are now one stage further on than we were before, that was the event that was awaited. We have now made some progress. And the related point is, if either or both parties decide not to appeal, that will give us a better indication of the likely time frame from now on. But I agree in terms of the substance, it doesn't resolve the points.
Thank you.
Thank you very much. Mr. Edinburgh.
My lords, I was going to try and be very quick.
That would certainly be welcome.
Yeah. The first point is this point about review rehearing, which my learned friend pressed upon you. In my view, there was a slightly inappropriately put. In essence, obviously an appeal is a review, unless there are statutory reasons for it to be a rehearing. That's not the case here. The question is when you review, you're looking to see whether there's some mechanism whereby the appellate tribunal is permitted to look at the matter afresh. We say there is such a mechanism here because either the judge took into account the wrong things or the landscape is so fundamentally changed that his decision cannot stand in any event. Once you reach that hurdle and have overcome that point, then you stand in the shoes of the tribunal that needs to exercise its discretion. And therefore, you look at everything because you need to exercise your discretion, taking into account all things that are relevant and no things that are irrelevant. That brings me to the point with respect to the exhibits. If you actually look at what are in those exhibits, you'll find that they're all rather uncontentious things, such as copies of the earlier judgment of the deputy judge below, Mr. Carrot, and other correspondence and things like that. So they're not materially, you are not materially disadvantaged by not being able to read those exhibits. The point here about commercial certainty was if there is a stay of everything, there is no commercial certainty, save for the fact that the status quo of there being uncertainty for a long period of time is continuing. And that leads into this point about if you were to remit the matter, all that does is to lead to further delay. Delay seems to be the thing that the defendants wish to have here. There's a point about the recent decision in the Grand Board of Appeal. My Lord Justice Arnold has in essence answered that himself. The point being is that if there's going to be an appeal, we don't know yet, but that would lengthen it. If there is no appeal, then it's going to go back to the cancellation division, and that's the bottom rung of the ladder. And so therefore, there's going to be a delay. So what you can say is there's going to be a delay. We don't know how. How much of a delay, we don't know, and that leads to the phrase that my Lord Justice Arnold said, indeterminate period of about 5 years. Doesn't upset that. With respect to the hearing before the judge at first instance, it was a CMC. There was a separate freestanding application for stay by the defendants. And actually, the bulk of the hearing before the judge was the stay application, because in essence, the CMC directions flew out of that, or the parties were going to agree. We nearly agreed to everything. You can see that from the skeleton arguments at first instance. Those are included in the supplementary bundle. Yes, there's just one last point, and that is in our reply skeleton, which is behind tab 14, and in paragraph 11, various possibilities were set out that might lead to some sort of commercial reality. That was a non-exhaustive list. You can see that from the introductory parts. And one of the suggestions was, well, there was no talk about an infringement, finding of infringement with respect to the UK Chevron Mark. That would actually, in of itself, lead to some commercial certainty. And the reason I can say that is because in the witness statement of my client, Mr. Pepton, you'll find this in the supplementary bundle behind tab 9, and in particular paragraph 8b, little Roman 2, page 88. He says, if the results, that is of any hearing that we do have, is that the crafts infringe the Chevron or Symfonie marks, I confirm that we would take the items down from our website, thereby reducing any harm to the defendants and limiting the scope of damages until such time as the validity of the said marks is determined by the EUIPO. That's actually the said mark. So that's another way that there would be some sort of realistic, sorry, let's put it the other way around, some indication of how the parties, at least the crafts, would respond realistically to an outcome, one of the potential outcomes at IPEC. And that really is, the final point being is that my learned friend said it was foolhardy in essence to speculate. Well, you've got to do some speculation, because otherwise you're just deciding in the dark. You've got to make some thoughts as to what may or may not happen with respect to the various consequences. So you do need to look at the various options. You can't, but you are warned, remember in the last paragraph, paragraph 15 of the IP con case, you shouldn't go into detailed consideration. So it is a bit of a broad brush. So that overall, justice can be done. That was the thing that was reiterated twice in IP con. And we say the way in which justice can be done in this case is for there to actually be some decision. My lords, just in time. I will stop.
There don't seem to be any further questions, so thank you very much. Thank you very much, both of you, and indeed others who've been involved with this. As you'll have gathered, judgment will be reserved in accordance with what has become the current practice. It will be handed down remotely without any need for anyone to attend in court. Also, in accordance with normal practice, you'll be supplied with the judgment in draft for you to correct our English and similar things, but obviously not to re-argue the case. And we would be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you disagree, we would like, please, brief written submissions, and we would expect to resolve the points in the order that we make. Finally, I'm sure you have well in mind the concern that has been expressed more recently about compliance with the embargo. I think you've supplied addresses already, haven't you, to which the draft should be sent. But in any event, I would once again remind you of the need to comply with the embargo. We'll leave it there. Thank you very much.
All right.